case briefs, and so much more. LSData's got what you're looking for.
In 1965, the United States Court of Appeals for the District of Columbia Circuit heard the case McKey v. Fairbairn, which examined the responsibility of landlords and tenants in cases of injury. Levi McKey, who had rented a house from Euphemia L. Haynes in a month-to-month agreement, was held responsible for keeping the premises in proper repair. His mother-in-law, Agnes Littlejohn, slipped and sustained injuries due to a leaky roof, which led her to sue the house's owner and its agent. However, the trial judge directed a verdict in favor of the defendants, as the tenant was deemed responsible for repairs. During the trial, the lower court decided that the plaintiff's negligence claim could not hold against the defendants and refused to admit housing regulations into evidence. Littlejohn's appeal failed, as the higher court ruled that her injuries were due to her own negligence in not taking reasonable care to avoid the dangerous condition. The court affirmed the lower court's decision, setting a precedent that landlords are not responsible for injuries if tenants are in charge of making repairs.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.